We are back, Lawyer Talk Podcast Q&A edition. For those who watch this, sometimes I read a question I get in the comments. Sometimes I read a question I get by email. This time I'm going to summarize sort of a plethora of questions that we have had in recent times about DNA evidence. And maybe it's because we talked about DNA in a case. But look, DNA is such a ubiquitous, meaning it's this like people hear DNA and everybody's got their own connotations of what it means. And DNA is fresh on my brain because I just came off of a hearing where I took testimony from, on my side, 3 different DNA experts, and the government called their own 2 or 3 DNA experts. So I'm all over DNA evidence right now. And I want to talk about what it is and what it isn't and what you can do. First and foremost, I think there's this thought that if a jury hears DNA evidence, and I think some of this is true, if a jury hears, oh, this guy's accused of rape or murder or whatever, and his DNA evidence is there, he must be guilty. And the problem nowadays, and that was, I think, more true at some point in, believe it or not, in the early days of DNA. And here's why. In the early days of DNA, in order to get a DNA profile, it took a pretty decent amount of DNA. I mean, you would have to leave behind a good chunk of DNA, whether it's fluids or whether it's skin cells or whatever it would be, to get a good comparable profile. But nowadays it's different. So any of those who remember the COVID-19 testing, you may have heard like they're cycling it up, or they're, the DNA is like that. So they'll take a small amount of DNA and they'll duplicate it. They'll cycle it up. And by doing that, they can create a bigger profile or bigger sample that they can then compare. But the point I'm telling you is, or the point I'm trying to make here is that we can have DNA matches that can be compared to somebody with the tiniest amount of DNA. I'm talking like just a handful of human cells, like 20 human cells. And think about that. So it's like hardly any. So it can look like on a piece of paper, a report from the government. Yeah, we had DNA on this girl's underwear, and we compared that DNA to maybe, say, whoever, and it matched. And it looks like the guy must have done whatever was being alleged. Here's the problem. The efficiency of DNA detection sometimes overstates the importance of or the significance of the DNA. So there are cases, for instance, where somebody's DNA was found under the fingernails of a murder victim. And this, I think, happened out in California. That's a real case. And because that individual's DNA was found, it was like a homeless guy's DNA was found under the fingernails of a murder victim or something like that. And they found this homeless guy, and he was charged with the crime. Well, it turns out, and I'm probably butchering the facts, fix me in the comments and we'll kick it around. But it turns out they found out that the homeless guy who was accused of the crime was like in a different stratosphere. It was nowhere near the crime when it happened. So everybody thinking, well, how does this happen? How do we get his DNA here in an amount that a government expert is willing to come into a courtroom and say, this is the guy? And a medic who worked on the victim apparently had also worked on the homeless guy at some point. And that was sufficient enough to transfer the homeless guy's DNA in a detectable amount to the murder victim. And this is sort of like, holy crap. And I had an expert coming in my courtroom a couple weeks ago who said the following, and I found this sort of fascinating. He said, look, if I were called as an expert in that case in real time, I would have said it's probably the homeless guy, or the homeless guy probably had contact with the deceased in order to deposit that DNA there. And then he looked directly at the court or the judge and us and said, and I would have been wrong. I would have been wrong. And he made a comment like, look, we draw these conclusions about how DNA gets to a certain place at our own peril. We have to be very cautious. And what he's really saying is, all right, government scientists, I get it. You're coming into a courtroom and you're saying, look, in our opinion, it had to have been a lot of rubbing or a lot of contact or a lot of this in order to deposit that skin cell DNA there. And what our expert was saying is, look, I was on board with that at one point, but not anymore. And he was quoting things like studies where they would study household laundry. So, for instance, they would check maybe somebody's underwear or somebody's article of clothing in their drawer that had already been washed. And they would find DNA of one of the other people in the household on that underwear. And mind you, this is households without any sort of accusations of wrongdoing. And my point is that in a case where I'm defending, say, a sexual assault in that household, everybody would draw the conclusion that the DNA only got there by virtue of the sexual contact or conduct that is being alleged, and not some laundry transfer, not some household transfer just by virtue of living in the house. So this is my warning to everybody, both accused of crimes that you didn't commit, or maybe crimes you did commit, I don't care, or attorneys who are defending DNA cases. Get an expert. Get an expert. And this is, it may go without saying for some of us, but for others, not so much. You got to get an expert. In order to analyze DNA, you should have an expert, and you should have the expert assist, if you don't know how to do it, get bench notes and lab records that are created by the government DNA lab. These are like the graphs for the electropherograms and a bunch of scientific mumbo jumbo. But get an expert, and your expert can look through those records for you and tell you, look, there's not very much DNA here. This is easily consistent with some sort of innocent transfer. It might give you a defense, or it might tell you don't have a defense. But if you don't do it, you don't know. And that was part and parcel with the arguments I was making at my hearing. And it's very possible that, not even possible, it's likely, and it's happening, that people are getting convicted on stuff like this when they shouldn't. And we can no longer take DNA evidence for granted that your client is guilty or that a person is guilty. The media will blow that horn at times. The prosecution certainly will, and maybe even defense lawyers will say, look, they got DNA. All I'm saying is it is not so cut and dried. The testing, and here's the paradox, the testing has gotten far more efficient and accurate, and that has resulted in far less efficient and accurate conclusions that can be drawn from it, because the amount of DNA that's detectable now is so small that it can get there in all sorts of ways. So anyway, DNA. And by the way, on Lawyer Talk here, I've got an expert lined up. I'm going to come in and we're going to really kick this around and talk about defending DNA cases. So if you really want to geek out with me, stay tuned. It'll come soon. But until then, this is Lawyer Talk Q&A style, off the record, on the air.